Welcome to another episode of Beyond the Black Letter Law. My name is Marc. I'm the marketing manager here at DTOS Group. And with me today is Johanne Hague, in partnership with us from Prism Chambers, a partner at Prism Chambers. And our guest today is Caoilfhionn van der Walt, who is from Regan Van Roy Tax Consulting Firm. So thank you so much for joining us, Caoilfhionn. We're really excited about this episode.
Thanks, Marc. It's a pleasure to be here with you.
Great. Cool.
So, Caoilfhionn, I guess the first question is, what brings you to Mauritius?
Yes, so it's quite a long story, but I'll give you the short version. So I'm Irish, which is why I have such a strange first name. Married to a Burki from South Africa, which is why I have such an Afrikaans surname. And I started my career in London. And then when I met my husband, moved to South Africa. And I spent about 12 years in South Africa doing basically international tax work. And then I set up Regan Van Roy in 2016. And our focus is on international tax and structuring for Africa. And any time you look at international tax or structuring for Africa, Mauritius is always a very important part of the equation. So quite early on in Regan Van Roy's journey, we decided we wanted to have a presence in Mauritius to be able to properly explore the benefits of Mauritius in terms of the African jurisdictions in particular. So I moved here in the beginning of 2019, I think, and I've been here since.
3 years. So
just 4 years, what year was it?
Time goes by so quickly.
It will be 4 years in January. So yes, 2019.
Yeah.
So before the pandemic and all of that.
Yes, in the pre-pandemic world, and in fact, being locked up here during COVID was a great way to feel properly embedded in Mauritius. So now I definitely feel more Mauritian than South African.
But do you think that with all the changes during the pandemic and also post-COVID in our tax landscape, our tax legislation, do you think Mauritius still remains an attractive jurisdiction for South Africans?
Yeah, so I think one of the key points is we say we're a structuring specialist firm, so we don't only focus on tax planning. And for us, when you're talking about structuring, which is essentially about wealth protection, asset protection, and also tax optimization, the key driver is not tax. So certainly from an African perspective, and that includes South Africa, big issues that people want to structure around, big risk areas, are one, country risk. So people want to have a kind of plan B, that option if things go pear-shaped in their country of origin. They also want to have a facility that's in hard currency. So in South Africa, because of exchange control, your wealth to a certain extent has to remain in ZAR. So you're always going to have more exposure to ZAR, which is a soft currency, than if you have an external structure. Also, exchange controls are very stringent in South Africa, so moving to or setting something up in Mauritius can give you a base where you can operate in hard currency and outside of exchange control. And only after that is tax optimization relevant. And for us, South Africa, I mean, it's got a fairly high corporate tax rate, so 28%, soon to go down to 27%. The individual high tax rate is 45%, so not ridiculously high in the grand scheme of things, but in the South African landscape, the secondary taxes are always, we think, a bit more concerning, and they can be quite punitive. So if you're a shareholder in a South African company, you pay 27% corporate tax, but then you also pay 20% dividend withholding tax, which means an effective 43% corporate tax, which is very high. Then if you sell your business or you sell an asset, you pay CGT at basically 20%, which is also high. Mauritius obviously has no capital gains tax at all. And there's also high estate duty, so it's about 23%, different thresholds apply. Again, in Mauritius, there's no estate duty. So there, and also donations tax. So donations tax is a big issue in South Africa. So yes, in a nutshell, first of all, we believe that any structuring plan should not be purely driven by tax. And certainly when we structure in terms of the South African or the African context, tax is only one of the benefits we're trying to achieve. And two, yes, definitely Mauritius still remains attractive from a tax optimization perspective.
It's good to hear.
Yeah. Caoilfhionn, so tell me, what are the three main tax concerns that South Africans should have, when wishing to invest in Mauritius, either in property or otherwise, that they kind of need to bear in mind?
Yeah, that's a question I wish more people would ask, because a lot of people just kind of come over and invest in Mauritius and or move to Mauritius and kind of think they don't need to worry about South African taxes at all. So I would say the first one is consider your tax residence. So if you still remain tax resident in South Africa, i.e. if you have not formally tax emigrated with SARS and paid an exit charge if required, then you will still have to file a full South African tax return and pay South African tax even on your Mauritian income. So that's the first thing. You can't just move here and automatically SARS can't touch you anymore. You have to understand your tax residence. Another issue I would say is all of the South African anti-avoidance rules to do with a South African business or person trying to shift profits overseas. And South Africa has got a very, very sophisticated set of tax rules to stop this. So there's residence. A lot of people, a lot of South Africans set up a company in Mauritius, a management company does everything for it, but actually all of the decisions happen in South Africa. If that's the case, the company is still actually tax resident in South Africa and has to pay tax there. Wow. There's also transfer pricing. So if likely whatever the South African sets up in Mauritius will be connected to whatever he has in South Africa. So if there's any transactions between them, even if they're not formally documented transactions, but like, let's say, shared services, they have to be recompensed at arm's length terms, and you have to have documentation to support that. There's also quite detailed control foreign company provisions, which means if a South African company or person sets up a foreign entity, that foreign entity, if it's more than 50% held by South Africans in terms of what's called participation rights, which is basically very broad, then that foreign company can be subject to South African tax in the hand of the South African residents. So I think that would be the second one, which is so first is make sure you know where you're resident. Yeah. Second is beware the very far-reaching and complex South African anti-avoidance provisions. And the third one, which is relevant, I think, for South African retirees who move here, is these deemed succession rules in Mauritius. A lot of people aren't aware of these, but if you die while resident in Mauritius, you can't just you can't just dictate your will as you wish. There are specific requirements around, basically you have to give away a portion of your assets to your children. So that's something that does catch a lot of people out. So our general rule would be plan carefully in advance.
Okay.
Yeah, which I think that as you rightly point out, sometimes it just seems to them as easy as just packing my bags and moving there without fully thinking through. So just to come back on the first point you mentioned about the tax residence, how easy is it to move your tax resident as an individual? Is there an exit tax? Do you have to pay taxes in SA before you can actually move?
Yeah, so the answer is it's easy if you do actually move your residence. So the way the rules work in South Africa are your tax resident in South Africa, if you've spent sufficient time there over 6 years, which let's assume everyone will have, because let's assume it's a South African resident. Sure. Or if you're ordinarily resident there, which means that South Africa is really your true home, and there's a lot of court cases about that. Unless you are found to be exclusively tax resident in another jurisdiction by virtue of a double taxation agreement. So most of our clients, let's say if you've moved from South Africa, you would de facto be considered as ordinarily resident in South Africa. Then if you move to Mauritius and you become tax resident in Mauritius, which is essentially if you spend more than 183 days in any tax year, the tax year running from 1 July, or 270 days over 3 consecutive tax years. So then you become tax resident here, then you apply for your tax number, and then you can start to apply the double taxation agreement between Mauritius and South Africa, because South Africa is considering you resident in South Africa because they still think of you as ordinarily resident, sure. And Mauritius is considering you as resident based on your time spent in Mauritius. So most DTAs have tiebreaker tests both in terms of companies and in terms of individuals. And for individuals, there's 5 different tests. The first one is basically where you have a permanent home. Now, it's important to note that the permanent home does not have to be purchased. So if you move to Mauritius and you still have a house in South Africa and are renting a home here, that doesn't mean you fail the test in terms of the Mauritius residence.
Oh, okay.
So your South African homes should not be available to you, so it can't be sitting there, you know, with the
waiting
cleaning
for you
lady.
to come back.
Exactly,
Yeah.
it has to be rented out, or, you know, in whatever sense it be determined. It cannot be available to you, and your home here can be rented. It has to be your home. So often people will have 2, you know, often they'll have their house in South Africa and they'll have a house there. So then you go on to the next tests, which are basically, that they're quite similar, the centre of vital interest and the place of habitual abode. And that's to do with how much time you spend in the 2 countries and how linked in you are to the underlying environment and culture. And they look at things like where your children are, if you're working, where you're working, are you part of a school, are you part of a gym? It's quite far-reaching. So that's why we say that if you really have moved, it's easy to demonstrate that your place of habitual abode is in Mauritius. But actually, if your wife and kids are in South Africa and you come here Monday to Friday and you live in like a rented 1-bedroom apartment and every Friday you go home to your, you know, 4-bedroom house in Camps Bay, it's unlikely that the test in terms of centre of vital interest would fall here.
Wow.
So it's quite subjective, and it's easy if you definitely have moved and you've, you know, sold your house or rented out your house, your kids are in school, you spend most of your time here. But it is not easy to kind of try and book the system by just pretending you're here a certain number of days. And especially, we say, if you have a married couple and one of them remains resident in South Africa, even from a tax perspective, while the other remains tax resident here, that could be a red flag. And we do often see that. So to mitigate the exit charge, which I'll come on to in a minute, often we have one person tax emigrate to Mauritius and the other person not. And although technically there's no reason why you can't have a married couple choose 2 different countries as their true home, you know, obviously that's a red flag to SARS. So it's something, unless it's a clear-cut case, it's something that should be treated very carefully, and it really depends. We say basically if your whole family isn't with you, and we're talking about minor children, then it gets trickier. Then in terms of the exit charge, so South Africa is one of the few countries that give you a kind of final kick on the backside when you exit. So you can't just kind of leave and say, bye SARS, I'm off, I'm not going to pay you any more tax. You're actually deemed to have disposed of all of your assets at market value the day before you leave. Wow. So you end up paying the worst type of tax, which is an actual cash tax on income
something that you don't
receive.
have. Yeah.
So the exit charge is quite complex. It excludes anything that South Africa can still tax. So it excludes South African property, because even if you're not resident in South Africa can always tax that. And it excludes your retirement annuity. But everything else is subject to tax. Now, for a lot of people, they don't really have much in the way of assets, or they only have South African property, so that's not a big deal. But if you have a big share portfolio and there's a big inbuilt capital gain, or let's say you bought a flat in London 20 years ago and there's a big inbuilt capital gain, your exit charge can be extremely high. So especially when it comes to wealthier people, or actually more often older people who haven't really done much tax planning in their past, often it just becomes unfeasible for them to tax emigrate. And it is certainly possible to live in Mauritius, even to retire in Mauritius, but to remain tax resident in South Africa. And to structure your revenue flows in a way that it's not punitive. So the exit charge is something that needs to be considered very carefully.
What's the rate of the exit
So
charge?
it's a sliding scale, but it's basically 20%. So it's quite high.
Yeah, especially for money that you don't have.
Yeah.
Well, and would that also apply? Presumably, there's another charge for that, and we'll probably get to that later. Would that apply if the shares, the portfolio of shares, actually held in an offshore trust, so they don't actually belong to you anymore?
No. So generally, international trusts work very well for South Africans because, and sometimes we think that people don't really understand this well enough. Because if something is held by a trust, the person doesn't own it. The trust owns it. The person does not actually have any ownership rights. So that means that when the person emigrates, he is not counted as holding the things that are held in the trust. So that's why typically wealthier clients have already put their offshore assets into an overseas trust, so they're not caught by the exit charge. Sure. And that's why it's quite difficult. It's often kind of, just your general hardworking pillars of the community who've built up their own personal wealth and want to emigrate, and they simply cannot afford to pay the exit charge to do so on, maybe, especially if a person has built up his own business, then he owns shares in his company. And even if he owns them through a South African trust, because until recently he couldn't hold them through an international trust because that's a loop structure, but then the cost for him in terms of the market valuation of his company, when he probably built it up from zero, he just can't afford to emigrate and pay that cost. And similarly, when he dies, the estate usually will be very high. If he sells the business, it will be subject to CGT. So these are the kind of secondary taxes that actually can be quite punitive for South Africans that careful structuring can help alleviate. Yeah.
Sorry, I was just going to say one more thing, but please.
Does it work the other way around? So let's say you immigrate, you financially immigrate, you got to pay your, what was the fee we called it? Your exit charge. What if 5 years down the line, let's say you've left Ireland and now you want to move back to South Africa, how does that work?
So how it works in theory, and this happened when I moved to South Africa, I became resident 6 years after moving. What you do is you bring all of your assets you have to disclose them to SARS at market value on the day you become a resident. And then when I emigrated 12 years later, I had to pay capital gains tax on the difference between the day I became resident in South Africa, so not the day I acquired the assets, and the day I left. So obviously in practice, and we do work a lot with South Africans who've emigrated who now want to return to South Africa, in practice there's good ways to structure so that when it comes to re-entering the South African residence system, your assets can be protected.
That is very, very interesting. I've got to ask, I know you touched on it a little bit with the double taxation treaty, but does it help South Africans moving to Mauritius in any way?
Yeah, definitely. It does. So in general, where there's a double taxation treaty, it just means you're at much less risk of suffering double tax. And particularly in terms of the residency, it's very helpful because you don't have to prove you're no longer ordinarily resident in South Africa, which is very subjective. You just have to prove that under the South African Mauritian double taxation agreement, you're exclusively resident in Mauritius, based on those tests I mentioned. Okay. So that is much more tangible than arguing I'm no longer ordinarily resident. So yes, it is helpful to have the double taxation agreement, and also because on certain income streams it dictates, no, only Mauritius can tax this, only South Africa can tax that. Okay. The one funny, if I can mention, to do with the South African Mauritian double taxation agreement, which we do think people don't worry enough about here, is we spoke about the tiebreaker clause for individuals. So if you're found to be, if you're a tax resident in two countries by virtue of the domestic law, the tiebreaker will say, okay, you're only tax resident in this country. Normally, double taxation agreements have a tiebreaker also for companies. So it says, if you've got a company that's, let's say, incorporated in Mauritius, but effectively managed in South Africa, or considered resident in South Africa because it's managed from there, then the tiebreaker will kick in and it will say, okay, it is only resident in the country where it is effectively managed. Now, the Mauritian-South African double taxation agreement does not have that tiebreaker. So it means that if you have a Mauritian company that some of the activities happen from South Africa, such that SARS says, actually, this business is effectively managed from South Africa, and there is no clear definition of effectively managed. There's a practice note, which is, quite vague, and it's very, it's quite grey terms. But so then SARS can say, we're going to tax it, so you have to pay full 27% tax in South Africa, and you still have to pay your Mauritian tax, and you will not get double taxation relief, and the tiebreaker doesn't apply, so what you have to do is get SARS and the MRA whenever they choose to do so, to agree between themselves where it's exclusively invested.
Yeah, it's quite harsh. There's a famous case actually in
that caught up on this. Yeah. But this is something that we tell people, POEM, the place of effective management, is what you really, really need to worry about if you're a South African, especially if you're still living in South Africa, who set up a company in Mauritius.
Okay.
And so the South African Mauritian DTA will not help you there, whereas most double taxation agreements would help you in assigning exclusive residence for a company.
Wow.
What I find often is that, particularly when you have South African clients, they would actually go out of their way to make sure there's no South African resident director on the board of the Mauritius company, even though if it's just one of 5, even then they wouldn't want to take that risk. I've found
the difficulty is there's such a big difference between CMC, Central Management and Control, and Place Effective Management. Sure. And Place Effective Management doesn't give a toss about the directors, really, unless it's a holding company where the decisions are made at the shareholder at the board meeting level. So that is a concern. There's no hard and fast rules, and it entirely depends on the business that's at hand. And generally, we say it comes down to, if it's a proper trading entity, it comes down to bums on seats. You need bums on the ground in Mauritius, or you're going to have a risk.
So, Caoilfhionn, to come back to the trusts issue, I think we briefly mentioned that earlier. Do you think that, so I find, particularly with South Africans, as you mentioned, offshore trusts, whether it's Mauritius or elsewhere in the Channel Islands, are particularly popular for them. It's a particularly popular tool for holding their non-SA assets. What would you say are the main advantages of having an offshore trust?
The main advantages all are around the secondary taxes we were discussing. So, as we said earlier, it's important to note that if you hold your assets via an international trust, you do not hold your assets, the trust does. So your ownership link is broken. Now, because your ownership link is broken, it means there's no donations tax, so the trust can do whatever it wants with them. It's outside of the South African scope for donations tax. There's obviously no CGT because the trust can do whatever it wants. And it also breaks the the controlled foreign company link, because the trust owns, so let's say the trust owns a foreign company, that is not regarded as a controlled foreign company, even if all of the beneficiaries of the trusts are South African. So it breaks the controlled foreign company link. It doesn't break the connected party link for transfer pricing, which is important to note. And obviously it means that, similar to a South African trust, estate duty doesn't apply. Also, a benefit of having any intermediary entity, so it doesn't have to be a trust, but is that then your foreign funds can more easily be retained offshore, kept in hard currency and outside of exchange control.
Yeah. Do you have an offshore trust, Marc?
Oh, yeah. In it is my 50-foot yacht as well.
And your fleet of racehorses.
And my fleet of racehorses and my Ferraris. Yeah.
I think we could spend hours talking about, South African tax issues. Actually, it's
absolutely fascinating.
Yeah, there's so much to talk about. Thank you so much for being here today, Caoilfhionn. I'm sure maybe you can mention how people can get in touch with Caoilfhionn.
Yeah, sure. No, and to our audience watching and listening, so thank you so much for tuning in. And if you'd like to get in touch, all the details will be down below in the descriptions. And don't forget to follow all of us on social media channels like LinkedIn and Facebook, as well as Instagram, if any of you got Instagram. But thank you so much again for joining us, and we'll see you next time.
Thank you, Marc. Thank you, Johanne. It's been a pleasure to be with you today.
Thanks so much.
Thank you.